Okay, perfect. We are going to record. So thank you for joining. I'm glad that you guys are here. What we're going to do today is go through the 1-4 contract, just paragraph by paragraph, and talk about what should go in every blank strategically, depending on who you're representing and what situation you're in. This will be a million times better if you have questions. So let's just please speak up. Don't be shy. And what I'm going to do is I'm going to share my screen and just pull up the contract so we can go through here. Okay. So now you guys should be looking at the 1-4. Does that look correct? Yep. Okay, perfect. So since most of you guys are newer agents, please don't hesitate. We're going to do like the very basic approach. Please don't hesitate to ask questions. So we'll just go. So first of all, make sure you're using the most current version of the form. Like every once in a while, Trek will update terms to like make the form better. And they did an update last November. And so this is the form you're required to use now, the one that's dated November 7th of 2022. So, okay, well, we'll get going. First of all, before we start, does anyone have any specific questions? No. Okay, cool. Okay, so the parties to this contract are blank seller and blank buyer. And, you know, the seller, you're going to be able to ask the listing agent who the seller is. And one thing, if you are listing a property and, you know, usually it's pretty straightforward and it's like, oh, we're the, you know, husband and wife that owns this, or I'm the lady that owns this. But if there was pay attention, if there's any indication that they, you know, were married at one point when they lived in the house, or they inherited it, or there might be just something funny about title, it's always a good idea to reach out to Randy with Momentous and just have him confirm who is the actual seller on this property. Because it's one thing for us to sign a listing agreement with the person that we think has the right to like sell the property. It's another thing for us to have those people enter into a contract and then them not be the only one that has to sell. I had a deal once with an investment property where we got all the way to like 2 days before closing, and the title company figured out that there was like 6 other heirs that they needed to track down to sign. So like the deal died because I had just signed with like the lady that thought she owned it, but she had inherited it and there were some other people. The other situation you might run into is, you know, if a couple lived in the home when they were together and then they divorced and just the ex-husband owns it now, it may be a situation where the wife has rights and still has to sign. So that's a question for the title company. You're not just going to necessarily know that, but I just wanted to mention that to you so that you like remember that. So you put the seller's name in, you can just ask the listing agent or look it up in the tax rolls as the buyer, right? You can always look it up in the tax rolls and it's going to say who appears on title. But the listing agent can confirm that for you and they should know. And then, you know, the buyer is whoever you are representing, right? If it's, you know, Zareen Brendel and Matt Brendel, if we're husband and wife, you want to put us both in there, unless just one of us is buying it. So usually you put like all the parties. Okay. Any questions about that? No. Okay. So then the property, this is another one where you're going to put in, this is the legal description of the property. And you can also find that in the tax rolls. And if you go to MLS and you click Netris tax, the tax record is going to pop up. And you should save that because that's a required document in ReChat for us anyway. But this is where it will tell you what's the lot, what's the block, what's the subdivision, Highland Park edition or whatever, Greenland Hills edition, if it's in the M streets, and then city of, Dallas, and then what county is it in? So that's the legal description, the lot and block. And then also known as, and then you would put, 5200 Merrimack Avenue, Dallas, Texas, 75206. So that's where you put like the street address. Any questions there? Okay. All right. So then here is where, and this is actually one of the B and C are two of the topics that we get called about a lot as managers. It's discusses like what is actually being sold, right? Like what's attached, what can the seller take? Can they take their fridge? Can they take their stove? And generally speaking in Texas, the fridge does not convey unless they include it in the contract. The washer and dryer do not convey unless they include it in the contract, but the stove does convey. So that's just the general rule of thumb. And you need to read through here. The other thing that people fight about sometimes is chandeliers, fancy mirrors in bathrooms, both of which are attached and should stay. Curtains and rods will stay. you can see, you just kind of have to read through this: carpeting, shutters, awnings, mirrors, ceiling fans, attic fans, read through this and really get to know what's in there. If you're taking a listing and like they have, the family heirloom precious chandelier that they want to keep, my recommendation is to remove it before you take photos, right? And then there's no argument. There's no like, oh, well, it was in the photos, we thought we were getting it. And it's not like, oh, well, when we saw the house, it had the chandelier. And then the day before, when we walked through it closing, the chandelier is gone. So my recommendation is anything that's precious that the seller wants to keep that's attached, remove it so you don't have the issue. Or if you're not going to do that, then you have to write in here, the chandelier in the dining room or the master bathroom mirrors or whatever it is that you're removing, that's being excluded. Even if you put it in the MLS that you're taking those things, if you don't write it into the contract here, they are not part of the contract, right? So that's where you would say anything that would typically stay that they're taking. If they have curtains that they want to take, but they wanted to leave them up for the purposes of the showing, and while it was under contract, you need to write in here, primary bedroom curtains or dining room curtains and rods or whatever. Just be specific. I don't want to beat the dead horse, but we get a lot of calls about this. So you guys need to know what is included and isn't included. We also have a lot of fights about outdoor grills that like look like they're attached, but they're really not because they're kind of built in. So just be clear and be specific about it up front. Because if you are under contract and then you're arguing about it, a lot of times the agent ends up paying because it was the agent's mistake not to be clear up front. So just don't gloss over what this says and make sure that your clients are reviewing it as well. That makes sense? Okay, perfect. And then, like I said, even if there's like, things that they know that they want to take, this is where you write it in, even if you've put it in the MLS listing and made it very clear. Okay, so then reservations, this is where this says any reservation for oil, gas, or other minerals, which in Tarrant County is sometimes a bigger deal. There's a separate addendum for that. It's like the mineral reservation addendum, and we have a whole other class about that, but this is not where you write minerals. Okay, that's not the right way to reserve the minerals. There's a whole other addendum that you need to use, and the contract is very clear about it. Okay, so sales price. So the cash portion of the sales price, this is where you're going to put, this is the total price. And if you put in a number here in Zip Forms or in ReChat and a number here, they're going to add up to what the total sales price is. So this is the amount they're putting down. This is the amount they're financing. This is the total offer price. And, typically you're going to use the third-party financing addendum. Very rarely do we see loan assumption or seller financing, but if you're doing financing, you need to check this box. So it's come up a lot recently where this happens often with our agents where the clients want to present as if they're a cash offer, but they're really getting financing, but they don't want any contingencies. And they have changed the contract now so that if you are going to get financing, you still need to put in here you need to put in the amount you're financing, even if there's no contingencies on the financing. And we'll go through how to do that, but you are going to have to check this box. What happens is if you present as cash, but really they're getting a loan, when the appraiser calls to make their appointment to do the appraisal, it makes the listing agent super mad. It makes the seller super mad. And you just have a situation then where, the party on the other side felt like you weren't being upfront. So it's better just to say, here's the deal. They are getting a loan. There's no contingencies on the loan. These are the terms. We just want you to know, like, look at this offer as if it's all cash. There are no contingencies. And that's how you do it. It's better to just be upfront and disclose that. Okay. Any questions about that? No. Okay. So leases. So this is a paragraph that basically says, sometimes a property is either encumbered by a residential lease where there's tenants in place. Like I'm selling some investment properties right now and there's tenants in place. So I would have to check this box. And then there's a residential lease addendum that I would attach. And in that addendum, it talks about, here's a copy of the lease. Is the lease in good standing? What's going to happen at closing, et cetera, et cetera. Typically in Texas, when you buy a property that's encumbered by any type of lease, you're buying it subject to the lease. So the tenant is not disturbed. The buyer just becomes the landlord, and then the lease runs its course and the buyer decides whether to renew the lease or end the lease or whatever it is. Does that make sense? Yes. Okay. So then fixture leases, this was a good addition. They changed this form a couple of years ago to add this because, a lot of times people have put solar panels in place or propane tanks and there's a lease for those. And so now you can address that. And the addendum regarding fixture leases has you deliver a copy of the documents, and you talk about like whether those are going to transfer or whether they're going to be removed or how it works. Natural resource leases. This is one where if there's an existing oil and gas lease on the property, then the seller has to disclose it and deliver a copy of the lease or get a copy of the lease and deliver it. And please note, if you have a property that you're listing that has an oil and gas lease in place, and you need to gather that up front and deliver it so that you can check this box, which says that the buyer has a copy of it. Because note, and this happens a couple times in the contract, if there's something that encumbering the property like a mineral lease and the seller hasn't delivered it and they eventually do, the buyer has a certain amount of days to terminate after they receive the lease. So that's an out for the buyer. So you want to make sure as the listing agent that you've delivered them a copy upfront. So that's some seller homework, is to find that lease during the listing process, but before you go under contract. Does that make sense? Yeah, that's a best practice there for sure. Okay. So this paragraph 5 is super important. It talks about earnest money and option and paying for those. And so within 3 days after the effective date, the buyer must deliver X amount to the escrow agent at this address. And this much will be earnest money and this much will be option. So basically, the earnest money is the money that the buyer gives to the title company as like their sign of good faith. And it's like the skin that the buyer has in the game, right? It's the money that they're putting up to show like, I'm committed to this property. The option money in Texas is the money that you pay that gives you the right to inspect the property and then walk away, or really walk away for any reason. You don't even have to inspect, but it's basically an open-ended right to terminate, and you pay for those separately. The earnest money is one amount, and the earnest money may be refunded to the buyer if the contract terminates for some reason. Like the option money is a separate, smaller amount usually. And that is, you never get your option money back ever, ever, ever. And so the general rule of thumb is that earnest money is 1% of the purchase price. Now, if you're in a multiple offer situation and you want to show like we're really committed to this property, you may do more, right? Show like we mean business, like here's more. The option money is not as much because it's money you're not getting back. So typically I would say that you see that between, 100 and 1,000, because again, that's money that they're not getting back. And so escrow agent, this is where I would put like Momentous Title, Randy Ramirez, right? So that's the title company and the specific closer you want, or, Radican Title, Wendy Wright. That's how you direct it to the correct title company and to the correct closer. If you don't have a closer, that's fine, but hopefully you're putting Momentous and Randy anyway. And then this is where you put the office address, and his office is 3131 Turtle Creek. But again, if you're in a different office and you don't want to put Turtle Creek, you can put your own office address and we can coordinate like getting the earnest money. But this is where you put the address. So that's what that looks like. Sorry. 75319. So, it got smaller. It did work. I'm filling this out in PDF, which we don't typically do, but just so that you guys can see it. So that's what that looks like. And then, the earnest money on $1 million property might be $10,000 and your option fee may be $250. So that's what that looks like. We have had an agent one time mistake those two and swap them. And it was a very expensive mistake because she put $200 earnest money and $18,000 of option fee. And that was not money that her client got back. So be mindful of what's earnest money and what's option money. Any questions about that? No. Okay. And then if you decide to do like additional earnest money, it's pretty rare, but it sometimes happen. Just know that the form contemplates that you could do that. Okay. So then
what might be reasons for additional earnest money?
Like Angela was explaining yesterday in the backup contract, where you're in backup position, so you don't want $10,000 of your buyer's cash sitting at the title company, so you may just put $1,000 and then do $10,000 upon the amended effective date. Sometimes you just want to show you have more skin in the game. It does not happen very often, so it's a good question. I'm trying to think of a scenario where you might want to put some additional earnest money down, maybe after the inspection, or if you have.
So technically you could do maybe not 1% on earnest, but maybe like 0.5% on earnest, and after option period, the other 0.5%. Is that
Yeah, you could do that. I mean, it's kind of unnecessarily complicated, and your seller's going to be like, why don't they want to put their earnest money down? Like, are they just going to walk away? Right. If it's not enough money, like we used to be in the situation where investors would put just $1,000 earnest money and say, like, we don't want an option, but it's not hard to walk away from $1,000, right? So you want it to be a substantial amount that it would hurt the buyer to walk away from. So, and depending on the contract size, that number, and a $400,000 property, that may be $4,000 or $5,000. And a $2 million property, $4,000 or $5,000 for that buyer may not be a big deal. So you want it to be kind of proportionate to the sales price. I can't really think of a reason why you would start putting in additional earnest money here. It doesn't happen very often. It's a good question. Okay, so this is the way this works, is that so you have to deliver the earnest money and the option fee, as you can see, within 3 days after the effective date. And the effective date is the date that the last of the two party signs off on all the terms. There's nothing left to go back and forth on. They've initialed and signed everything, and they deliver it to the other party. So if Adam and I have been negotiating all weekend and all day yesterday, and his buyers sent me the changes that we had talked about yesterday during the day, and I could have my sellers sign it today and say, okay, they made that change, good, we initial it. They made that change, good, we initial it. Then once everything was initialed and I sent it back to Adam, that would make today the effective date, right? And that's the date that all the dates in the contract start from. So within 3 days after the effective date is when the buyer has to deliver the escrow and the option money. And it's super important that you do that in a timely manner. And the way that it works is obviously if the title companies aren't open on Saturday or Sunday or legal holidays. So, if the last day to deliver that is a Saturday or Sunday or a legal holiday, then it's extended until the next business day, right? So if it's, I don't know what's a legal holiday, Columbus Day, and you're supposed to deliver the option that Monday, it would just be due the next Tuesday. So that's that, just good to know. But that doesn't mean if we executed on a Saturday and Monday was a holiday, Monday still counts and you still have to deliver it on Tuesday. You still count those days if a holiday. It's only if it ends on a holiday or a Saturday or a Sunday. Okay. So then, whatever you deliver, it applies to option, then earnest, then additional earnest. And buyer is authorizing the escrow agent to release and deliver the option fee to seller at any time, because like we said, the option fee, once you pay it, it's gone. And then this is your termination option. So for nominal consideration, which the seller acknowledges in the buyer's agreement to pay that option fee, then the buyer has the unrestricted right to terminate the contract by giving notice of termination to seller within blank days. So that question is, how long is your option fee? Since it's been a seller's market for a while. Oh, sorry, I lost my form. Since it's been a seller's market for a while, we're seeing, sometimes no option, which I don't recommend because I think buyers should inspect their property, or very short options. But the challenge is that you have to arrange to get your inspector through during the option, and also any follow-up vendors. If they say we've identified this plumbing problem, you're going to want to get a plumber out there. So, the shortest option I would say would be like 3 to 5 days. That's very short. And you have to really have a good inspector that you can get to the property. Typically I would say 7 to 10. 14 is really long. So hopefully that gives you guys like a good range. Obviously there may be situations where you do longer ones or shorter ones, but generally speaking, I would say you see 7 to 10 if we're in like a normal market. Any questions about that? No, as a seller, you obviously don't want to give them this very long open-ended right to terminate. So shorter is better. And then please note here that notices must be given by 5 p.m. by the date specified. That was a change. It used to be midnight, and you'd be like waiting up at midnight to see whether your buyer was going to terminate, or you'd be negotiating back and forth on repairs. So they changed it to 5 p.m., which is great. And we always know as managers, if people are calling us between 3 and 4:30, it's usually because they're in like a pickle and the option's expiring at 5. Don't do that, right? Like, get your stuff done as soon as you can and start the negotiation on the repairs, even if you have a few days. Like, it's the worst practice to try to negotiate repairs. Start negotiating a repair amendment the day that the option expires. It's just bad. You don't know where the seller is going to be. You don't know where the listing agent's going to be. You just need to do it as soon as you can. All right, I will get off my soapbox there, but you have to give written notice by 5 p.m. that you're terminating, right? If you wait till after 5, you don't have your option anymore. So that's just something to be mindful of. Does that make sense? Does anyone have questions about how that works? Okay. So then, this point here, failure to timely deliver the earnest money. This is an important one. If buyer fails to deliver the earnest money within the time required, seller can terminate the contract or exercise their remedies by providing notice to buyer before the buyer delivers the earnest money. So that goes back to the situation where I was telling you, where we used to have investors say, oh, $1,000 earnest money and I'm not inspecting. And then they would never deliver their earnest money. And we would be like stuck in a contract with no way out because sellers really don't have a way to get out of the contract. So they changed it. So now if the buyer doesn't deliver the earnest money in a timely fashion, the seller has the right to terminate after 3 days. But if it's the 4th day and the seller hasn't terminated and the buyer does deliver their earnest money, the contract is still valid. So it becomes a race for the seller to terminate before the buyer delivers the option money in that situation. So just something to be mindful of. And then this is very important. If no dollar amount is stated, meaning you don't pay consideration, or if the buyer fails to deliver the fee in a timely manner, the buyer does not have the option, period. So we had this happen a couple weeks ago where the seller had they thought they sent a wire, but they sent an ACH and it wasn't going to get there by 5 p.m. On the 3rd day. And it was like, why did they wait so long? And, and you just have to be really, really mindful. You want that money there by 5 p.m. To ensure that you have an option. What's up, Adam?
I think I have a question. So if seller doesn't give notice by the 3rd day, do they waive their right altogether?
No, the contract continues. But like sometimes this will happen, like in that situation, our buyer's agent reached out to listing agent and said, hey, here's the deal. Like he wants the property. He thought he sent a wire. He sent an HOA, an ACH. It's going to come on Thursday, the 4th day. Is that okay? And arguably because he had like started the wire before, or the ACH before the deadline, and it was like the bank failure that took so long, the seller was like, that's fine. And the deal just proceeded, right? So the deal continues, but if the buyer never deposits earnest money, it's like, are we really in a deal? The seller may want to be like, okay, well, I'm terminating and moving on, right? Because the earnest money is the buyer's like show of good faith that they're participating, and it's the leverage that the seller has over the buyer to perform. Does that answer your question?
Yes, thank you.
Okay. All right, perfect. Okay, so please note here in bold and conspicuous language, time is of the essence for this paragraph and strict compliance with time performance is required. Time is of the essence is like a legal term of art in the state of Texas. And just what that means is that strict adherence to deadline. So like, for example, our closing date in this contract is not an of the essence provision. In fact, none of them are except for this one. And that basically means that if you don't close on the date of closing, you're not automatically in default. Now, a party might argue that you're in default, but technically you have a reasonable amount of time to get to the closing table. So it's not like you're automatically in default. So just know that for the purposes of paragraph 5 and delivering your earnest money, delivering your option, delivering your notice of termination under your option, those are all strict compliance to the deadline. So good to know. Okay, so title policy and survey. So here you're going to say who's paying for the title policy. And generally speaking in Texas, historically, the seller has paid for the premium, but also then gets to choose the title company, which is why it's in our MLS. If the buyer is like insistent on using a certain title company and the seller doesn't want to, then the buyer should pay for it and then they can choose. So whoever pays for the title policy gets to choose, but it is a negotiable term. A lot of people sometimes don't fight that hard for whoever. We obviously hope that you pick Momentous, and you just say, you don't have to say Randy, you can just say Momentous title. Because, we'll have your back and we'll be watching dates for you and helping you out there. But, that's a negotiable term. And on our website, and anywhere, if you just Google Texas Title Premium Calculator, you can see like, what is the cost of the title policies, see like who's paying for it. So someone's going to pay for a title policy. And basically what a title policy does is the title company is giving the buyer insurance that they own the property free and clear with good title, except for these few exceptions that they note up front that they're not going to have coverage for. And these are standard pre-printed exceptions. They're all right here. That the title policy will the title company will give a title policy after closing that says you have good title. here's what's covered. These are the only few things that aren't covered. And it's these standard exceptions. And then there's one exception that your buyer can choose whether they want to have this extra coverage. And these are 8 standard exceptions, right? Or 9. There's one that's a standard exception, meaning we're not going to cover it, relating to discrepancies, conflicts, shortages in area or boundary lines, encroachments or protrusions or overlapping improvements. And that like might be an actual situation where like someone's fence is 2 feet over or your shed is on someone else's property. So you can either say, that's fine. We don't care. We don't want that. We don't mind if you accept to that. We don't think there's an issue with this property. Or the buyer can say, no, I do want to pay for an endorsement to the policy that's going to give me some extra coverage. And all of these things will be removed except for shortages in area. So basically normal in a typical situation, they'd be accepting to discrepancies, conflict, shortages in area, boundary lines, encroachments, protrusion. And what you would do is you would buy an endorsement to the policy that basically says their only exception is to shortages in area and not the rest of this. So it's an additional cost, but it's an endorsement to the policy that just makes the policy that much stronger. And then you say, who's going to pay for it? It's not super expensive. It's 5% of the cost of the total premium to get this endorsement. So I mean, you have to be able, obviously we manage the process, the buyer manages the decisions, but you have to be able to explain to them whether they want that coverage or they don't want that coverage and what that coverage will give to them, right? It's not super expensive. So my recommendation is just, I would never want to be the person that's like, don't get that. And then in 2 years they have an issue and we did not buy that extra coverage, right? So, my recommendation, if they ask, I would say, I would just go ahead and get it. It's not hugely expensive. And you can even calculate the cost by doing 5% of the premium, or just call Randy and be like, what would be the cost of this coverage here? And he can tell you the like exact number.
I mean,
Does that make sense?
would you be strategic and say, check 2 and then put seller?
Yeah, you could do that. I mean, it just depends if there's 8 other property offers on the property, your buyer may be like, I'm happy to pay for that. Right. But if it's a normal market, that's very negotiable. And I would say like what we were seeing before we got into this crazy market last year is that it was about half and half. Sophie, do you have a question?
Well, yeah, I mean, I was just going to ask, like, are you seeing that in these multiple offers, people are putting that this will be at buyer's expense for both of these boxes?
I mean, I can't speak to right now, but yes, last spring when it was so crazy, buyers were paying for everything. And I mean, if you get it's 6 in one, half dozen in the other, if you actually do the math, right? And a listing agent that's really good should kind of sit down with the seller and say, okay, well, this buyer has actually asked you to pay for the title policy, but they're offering $50,000 more. And the cost of the title policy here is $12,000. So even though the seller's paying for it, this is a better offer. So you just have to think of it that way. But yes, generally speaking, we were seeing like buyers paying for everything because we were over a barrel and there was no inventory. Does that help?
Yeah, for sure.
Okay, perfect. So hopefully that answers that. If you have more questions about this when you're doing a deal, just call me and we'll walk through it. Okay, so commitment, this means that the title company within 20 days, it's usually much quicker than that. The title company will deliver to the buyer a commitment for title insurance. And that basically says, and we have a whole other separate class on this, but it basically says, this is the status of title. This is what the insurance you're asking us to get. These are the exceptions that we're not going to cover, right? We just talked about that. And they'll give you copies of all of the exception documents. And these are all of the things that the seller needs to clear up in order for us to give good title, right? Like they may have a mortgage, they may have judgments against them, they may have IRS liens. Again, if you're a listing agent and you're dealing with a seller who you're like, I'm not quite sure about this seller, you can call the title company, call us, and we can open title and really pull it and see what's encumbering the property, see if they have tax liens, see if there's an X out there that's going to have to sign, of course, if you do that, if you ask a title company to open title, I recommend that you really stand firm when it comes time to negotiate who is the title company, because it costs the title company kind of a lot of money to open title. So that's my recommendation there, but we're happy to do it for you. And basically they're going to give you this title commitment that says, this is everything affecting the title of the property. And we have a whole separate class to go over what to look for in there. So please keep coming to these Tuesday and Friday classes because we will cover that so that you can be sure you're doing a good job when you get these documents. But another thing that they're going to deliver to you is a survey. And this is another thing that the title commitment will discuss. What does the survey show and how are we covering it? So the survey is typically your seller may have a survey that you can deliver. If they can't find it or they don't have it, you can always call the title company where they purchased it because they will have a copy of it. Or you can just get a new one. And so generally speaking, the seller has it, or they can get it from their last title company. And you say, within X amount of days from this contract, the seller's going to service to the buyer, the existing survey and a residential T47, which is a property affidavit. So you give them the old survey, and then the T47 is an affidavit that the seller fills out that says, since the date of the survey, these are the changes to the property. And then together the title company will use that to make their objections. So please note, if the seller fails to furnish either the survey or the notarized affidavit within that time prescribed, whatever you put here, then the buyer can automatically request a new survey at the seller's expense. So at Briggs Freeman, it's our best practice during the listing, when you're gathering all the documents and the mineral lease and the things like that we talked about, you have that, you make sure that they find their survey, and you make sure that they get that affidavit signed. And there's notaries everywhere. All of our front desk coordinators are notaries. There's a notary at every bank. There's notaries at the title companies all have notaries. It's very easy. You just need to get that done as part of the listing paperwork so that you can just deliver it. And there's no question here. And the reason that I'm harping on that is because, if you don't deliver both the survey and the notarized affidavit within that time, the buyer can automatically get a new survey. And if that happens, usually the seller's really mad and the listing agent ends up paying for it. So, and it's, $600 to $1,000. So you don't want to do that. So just make sure they gather this up front. And if they don't have it, they don't have it. And then you check one of these boxes and you say, within X amount of days, the buyer will get a new one, or the seller will get a new one. And typically I would say do that after the option. So, if the option's 7 days, I would say within 8 days, because as soon as the option's over, they should order the survey. They don't want to go to the expense of ordering it without. If you're the seller and you're selling the property and you're going to pay for it, you might as well just do it, within 3 days or whatever, you can order it. But as a rule of thumb, if you need to get a new survey, I recommend that the buyer pays for it, because then the buyer has, it's called privity of contract, but they have a direct contractual relationship with the surveyor. So if there is ever an issue, you can file a claim under your title commitment, but you also have a direct contractual relationship with the surveyor. That's me being an anal retentive lawyer, but that's my best tip there. I would do that. I also think that when you guys are advising people to buy these very large assets, that it just makes sense to have a new survey. If the survey is 10 years old, you don't know if the neighbor has built a fence or moved their driveway or built a shed or whatever. I just think your title policy is much more valuable if the survey is new. So my recommendation, if you're helping someone buy, it's one thing if it's not a huge transaction, but when you get into these $1 million plus price points, I think makes sense to just get a new survey. Again, that's me being an anal retentive attorney. So not everyone has to do that, but you can explain that to your buyer. And I'm happy to always talk to your people too. If it's $1,000 and it makes their title policy that much stronger because it's a new survey, that makes sense to me. But that's a Zareen suggestion. That's not a Briggs Freeman suggestion. Does that make sense? Okay. All right. So moral of the story there are title companies that will be oh, don't worry about notarizing the affidavit. We'll just do it at closing. No, do not do that, right? Because you are required, it's so clear, you have to furnish the existing survey and a notarized affidavit, within those days. So just make sure to do that. Don't trust the title company that says, we'll just do it at closing. No, that's not how it should be. Okay, I'll get off that soapbox too. Okay, so objections. So this is a situation. So when you do get your copies of the commitment that shows everything the title company is not going to cover, and the survey and all of the exception documents that are underlying why they're not covering it, then the buyer can object. So the best example is we had agent who was helping buyers buy a property in Westover Hills in Fort Worth. And they had a builder, they had a plan of what they wanted to build, and they realized that what they wanted to build infringed on this like 15 side yard setback. So they objected to that when they got that title commitment, and the sellers approached the city of Westover Hills and got a variance and got that side yard restriction waived for these buyers. So the buyers knew that they could build the house. That's just one example. So typically what goes in this blank, you don't really need to put anything unless you know your buyer wants to add a pool or add a third story, or, you know, sometimes you might put if they want to do it as a rental property. So that might be something that you would object to, and you can specifically put that in there. And then the amount of time, obviously you want a shorter amount of time if you're the seller and a longer amount of time if you're the buyer. So if you get an offer from a buyer and the agent is clueless and didn't put anything in this blank, I would put 2 days or 3 days, right? That's a very short amount of time for a buyer to object, but don't leave it blank, because then they have until the closing date, right? And you don't want that. So I would put 2 days. If the buyer's agent writes an offer and they don't put anything in there, make it very short. If you're writing an offer and you want to put it in there, I would put at least 5 to 7 days, because if there is some issue, you're going to want to like have an attorney help you write objections, and you're going to need a little bit of time. So I would put 7 days on the buy side and see if the seller pushes back. Does that make sense? 5 to 7 days. Good. Okay. Yeah, this gets confusing, but what happens is then the buyer writes objections and the seller looks at them, and the seller has the opportunity to cure, or the seller may say like, well, we can't cure, in which case the buyer can terminate and get their earnest money back, or just waive the objections and proceed to closing. So when we get in really sticky situations where your buyer is looking for a reason to terminate, we may go to this, but it gets complicated and they kind of need an attorney. So I don't want to get too complicated, but just title objections can be an out if we get like super desperate and we don't have another one. Okay, so now I'm going to breeze over this because a lot of this is just statutory notices and you can like read through them. I'm not going to spend a lot of time because I'm already at like 9:38, but you do have to advise whether a property is or is not in a mandatory HOA. And if it is in a mandatory HOA owners association, you need to add the, there's an addendum that talks about the delivery of the HOA documents and who's paying for what. And it's really, really important. If it's just a voluntary HOA, like in the M Streets, then you can say it's not subject to a mandatory one. But please note, like there are single family homes that are in owners associations. If you're doing a condo, this is not the right form to use for a property that's a condo. There's a separate residential condominium contract resale that you should use, and it will go into a little bit more detail here. And in fact, you don't have to use the owners association addendum because it's built into that contract. Good. The reason this is in there though, because they do want people to be on notice that if you're buying a property that's in a mandatory HOA, like you're going to have assessments, you're going to have a fee. And so that's why they put this in bold and conspicuous language. They don't want people to buy a property and then be like, I didn't realize I had to pay this much every month to be part of this. So, or year or whatever. And then this kind of spells out the addendum that you would use. Okay. So then there's more, this gets a little bit more complicated now because there's some notices, but these are just, you know, standard notices. And then here is where you need to be mindful. If the property is in a PID or a MUD or a PUD or a water conservation district, that just means that they have like a separate taxing situation, and there's required notices that you have to give, and there's forms for that, but you must deliver them and the buyer has to acknowledge receipt. And typically your seller will know if their property is in one of these because it will be reflected in their property taxes, what they're paying. Okay. We're going to do a whole separate class on this too.
If you're writing an offer on that, how do you know?
You probably just have to submit the offer and let them go back. You can look at the tax rolls and see like what the different taxes that they're paying, but you're going to be talking to the listing agent. Oh, sorry, my computer's acting like it's not plugged in. I don't know what's going on here. Okay, I'm going to have to relocate because it's acting like my charger's not working. Please hold. Okay, any questions about these? Sorry to gloss over the notices, but you can kind of just read them and see. Okay. let's try this. Okay. So then paragraph 7, property condition. Okay, so this is important. This is the paragraph that says seller shall permit buyer and buyer's agents access to the property at reasonable times, and buyer may have the property inspected. Basically, the seller, we get in situations where the buyer wants to go by like every day with their designer and measure things and like hang out in the house. That's probably not reasonable access. But it's also not reasonable for a seller to say like, you can't access the property, right? So the question is like, what is reasonable? Like sometimes sellers will be like, you can't do a walkthrough. And it's like, you can't, that's unreasonable to not let me walk through the property the day before I close it. So just know that it's in the contract that they have to give reasonable access. The question is, what is reasonable, right? Sometimes we have buyers who are unreasonable. And also that they can have it inspected, but that if you do hydrostatic testing, you have to have it separately written in writing, and there's a form for that. And also please note here that seller shall make sure that all the utilities are turned on and are kept on during the course of the contract. Like that's a requirement of the seller. So just be aware of that. Okay, so then here, this is the seller's disclosure. Either the listing agent has it or has posted it in the MLS and you say the buyer has received it, or the listing agent doesn't have it and they say, okay, well, we'll deliver it in however many days. Or it's a situation where the seller is not required to furnish it. If you think you're in that situation, please call me and we'll talk through it and confirm, because the exceptions in the property code, section 5008E, are very narrow. And a lot of times agents and sellers think that they're not required, and they are, even if they've never lived in the property, even if someone else was managing it. So you just need to know that this is very rare to check this box, and we can talk through it if you think you're in that situation. But please note here, like at Briggs Freeman, like one of our best practices is to get the seller's disclosure at the time of the listing. So as you can hear, like there's a theme here, like there's a lot of homework sellers have to do when they list the property before they go under contract, so that you can have a better, stronger contract for them. But you want the seller, the buyer to receive the notice before, so that they've seen it. There's no question that what they're going to see once they get it while they're under contract. If you do check this box because the seller doesn't have it, it's actually an advantage for the buyer, because you can see, if buyer does not receive the notice, they can terminate. Or if seller delivers the notice, buyer can terminate for any reason within 7 days after they receive the notice. So you're giving them like an open-ended option if they have not checked this box. You're giving them at least a 7-day option, right? Does that make sense? So that's why strategically at Briggs Freeman, we really, really want you to do this as part of your listing process and place it in the MLS and check this box. Does that make sense? Okay. That's how you can tell if you're dealing with a good listing agent or not. That's like one of the indicators. Okay, so you may need a lead-based paint. And then this is where there's some as is language, and it basically means that the buyer's accepting the property as they see it, right? Now, this is where you check that. That doesn't mean you can't negotiate repairs. That doesn't mean anything like that. This is generally what we're going to check. The only time that you check this box, whereas that they accept it as is, provided that seller does this. And the only time you're going to do this is if the seller has like marketed the property that it's getting a new roof, but it hasn't done yet, right? So you want to be sure to include that in writing, like whatever the seller has marketed is going to be done. Then I would type that in here, like, replace the roof or whatever they've said, replace the carpet. If that's part of the negotiations, because you don't want to have to add that in like during the option. You just want to say like, we're accepting it as is, except that they're getting a new roof, or except that they're fixing the sprinkler that was broken, or whatever it is. Does that make sense? Okay. So lender required repairs. So they're in an FHA situation, very rarely in conventional, but sometimes in FHA, the lender, when they send out their appraiser, they're also an inspector, and they'll come up with a list of things that needs to happen to the house that are required. And so, neither party has to pay for lender required repairs. Like the seller can, if they're like, okay, well, I want the deal to go forward. The buyer can, if they're like, I want the deal to go forward. If it turns out that the lender required repairs are more than 5% of the sales price, the buyer has the right to terminate, because they may be like, that's a lot of repairs. This property is in worse condition than I thought, and I don't want it anymore. So just to know that that's in there. And then this is an important paragraph, and it's actually changed in this version where unless agreed in writing, seller will complete all repairs prior to closing and obtain permits. The repairs must be performed by people who are licensed. So you don't have to write, repair plumbing by a licensed plumber. Like you don't have to write that. It's in the contract. Or if no license is required, they're commercially engaged of the trade. So like there's no sprinkler repair license, but the seller can't like roll up their sleeves and go fix the sprinkler. They have to hire a sprinkler company to do it. And then this is the new part. Seller shall provide buyers with copies of documentation from the repair person showing the scope of the work and the payment. And if there's any warranties attached, seller will arrange for the transfer. So that's new language. I will say that like Briggs Freeman agents, as really professional, good agents, were already A, doing this as listing agents, and B, requesting it as buyer's agents, like requesting proof of completion of repairs. But now it's in the contract. So agents that aren't like as professional as you guys have to do it, and you don't have to like demand it. It's like clearly in the contract that this is what a good agent does, is that they document everything that was done. And then the buyer has copies of who did the work, what was done, et cetera, et cetera. Seller fails to complete any repairs prior to closing, buyer can exercise their remedies or extend the closing. So good to know. Okay, this is a notice. This is residential service contracts. Buyer may purchase a residential service contract from a provider. If they purchase one, then seller shall reimburse buyer, not exceeding X amount. And so this is we recommend American Home Shield. We find that they're like the best home warranty company, and they can tell you, our representative can tell you exactly how much coverage you need, and so that your buyer may want additional coverage for the pool or something extra. So you can decide that in advance, but typically I would put like at least $600 to get your buyer what they need. And then if they want additional coverage, the seller is going to cover the first 600 and the buyer can pay the difference. Does that make sense? Okay. All right. Paragraph 8, this is where you have to disclose if you own more than 10% of the entity, or if you're related to a party in the transaction. And we always call it, what is it? Consanguinity, which means that you have to be a blood relative, right? Spouse, parent, child, a lineal consanguinity, which means like a descendant or a parent. So, but if I was selling my brother's house, I would still disclose it, because if you get into the deal and you don't mention that and then it comes up, then it's like, why didn't they tell us? Like, that's kind of weird. I'm just like a very much like be upfront and direct, so there's no surprises, so that we can like build trust, and so that there aren't surprises that break trust. But that's how I do it. Okay. And then broker's fees are contained in separate written agreements. Closing, again, please note, this is an honor before date. So you can close early if everyone's ready. But you put your date, again, this is not of the essence. So this is like the date that we want, but if the buyer's lender is a day or two late, arguably they're not in default, because that's a reasonable amount of time to be delayed. And if you ever get in that situation, call me. I have a really good Texas Association of Realtors FAQs that like explains that if you're arguing with someone about that. But at some point, I have a situation right now with another agent where we're arguing like at what point is reasonable. They're supposed to close on Wednesday, and they're either going to be able to close on Friday or Monday. And the seller's like, well, that's not reasonable. And they're like, well, it's 2 days. But then it turns from 2 days to 5 days, right, over the weekend. So it's like, what's reasonable? Probably they just need to do an amendment. But then the seller's like, well, I want you to pay for the extension. So just something to be mindful of how this works. Okay, so then it talks about at closings, what's going to happen. Every once in a while, if you have an attorney who's a client, they're going to cross out general and write in special, and that's fine. It's just a different kind of deed. Basically, they're warranting only that they have good title, and not that like everyone before them also had good title. It's fine. But if you have people that are crossing things out and you want to talk through them, just call me. Okay, so this talks about kind of what's going to happen. And then possession, is the buyer going to take possession right away, or are we going to do a seller's lease back? I do not recommend ever doing a buyer's temporary lease where the buyer moves in before closing. I think you're just asking for trouble. But, if there's a lease, if there's like a tenant in place, you're giving them possession upon closing and funding, because that's not a temporary lease. That's not a temporary lease, because they're technically getting the extent of the possession that the seller has. And then please note here in bold and conspicuous language, if you are going to do a lease back, you must advise your client to talk to their insurance person, because the seller, once they sell the property, technically arguably their homeowner's insurance, not arguably, I guess their homeowner's insurance is not in place anymore. and all of their contents don't have any coverage. So they might need temporary renter coverage to protect their like personal property that's still in the home. So you need to make sure that both parties explain to their insurance person, this is what's happening so that they can have the right amount of coverage. Temporary rental coverage is for personal property is not expensive. And then this talks about smart devices. And this was a change recently in the contract, and it's a good one because there were, there's iPads that control the brain of the home and things like that. And technically you need to deliver that and give all the passcodes and the access codes and the usernames. So that's now in the contract. It's very clear. So there's no confusion. Okay. Special provisions. You should never really write anything in here. If you do want to write something, please call me or Angela and we'll give you the language because we're both attorneys of what you should write. If you want, seller will have the property professionally cleaned prior to closing and provide a receipt, like fine. Sometimes people want to put a deadline on their offer. And if you do, that's fine. Like text me and I'll text you the language just so that your offer isn't hanging out there in perpetuity. I once wrote an offer for an investor and the listing agent called me back like 6 weeks later and was like, congratulations, you're under contract. And I like didn't even remember what she was talking about. She was one of those like listing agents that dealt with a lot of investment properties and had like a huge quantity of deals and not like obviously quality of service. So I was like, no, but she was right. I should have I should have either withdrawn the offer or made it expire on its own terms. So a lot of times people like to say like this offer expires automatically at 5 p.m. on Friday, April, whatever it is, 7th. 2023. And that just means that they can't come back to you on Saturday and execute, right? If they wanted to come back to you on Saturday, they would be countering you. Does that make sense? It's not like this offer self-destructs and it goes away and you're never talking to them. It just puts a deadline on it. You can never force a seller to respond, right? You can't say like, we have to have an answer by noon tomorrow. Because guess what? If you really want the property and they call you back at 2 o'clock tomorrow, you're probably going to negotiate with them. The only difference is that they can't execute and send it back to you after your deadline. Does that make sense? Yeah, we're okay. Thinking. Okay.
Makes
Okay.
sense. Thank you.
Okay, perfect. Thanks, Sophie. Okay, so paragraph 12 deals with settlement. And so 12A, and it talks about who's going to pay what at closing and how does this really work. So 12A1B, that's this guy, is the amount that the seller's going to pay on behalf of buyer. So a lot of times when you're negotiating repairs, instead of saying, I want seller to fix X, Y, and Z, you may upload your inspection into punch list and get an estimate for what the cost of those repairs is. And then just ask the seller to give you $3,000 so that the buyer can have those things done after closing themselves. And they just get to keep that extra cash in their pocket to pay for those repairs. So Punch List is this really awesome company we have where you can either on the buy side or the seller side, you can upload the inspection and within 1 business day, because we're Sotheby's, they'll get back to you and give you like an itemized list, an estimate of what each of those things would cost to repair. And then they'll actually do the repairs if you want. I've used it on the seller side before when we were selling an investment property last year. The buyer asked for X, Y, and Z based on the inspection. So I uploaded it into Punch List. They gave me an estimate and I was like, okay, fine, we'll do that stuff. And I just hired Punch List and they did it. It was actually really awesome. She had an issue after closing with one of the things that they fixed. So they went back and refixed it and I got like notified about it, but I didn't have to pay anything for it. So I highly recommend you leaning into Punch List, even just to figure out like, what is this buyer really asking for?
Zareen, real quick on that, can we use that for sellers like in advance of the deal?
Yes, they'll help you do make ready. Yes,
Okay.
absolutely. It's a really, really great system. It was invented by a realtor in North Carolina and his builder who he kept asking him to help with repairs. And finally the builder was like, dude, why do you keep asking me to fix these things really quickly? And so they came up with this company. I think it's super smart. There's a link to it through BF Office, but it's called Punch List USA.
Thank you.
So highly recommend. So 12A1B is the amount you're going to ask for. Now, I will caution you, do not ever write anything into this blank without talking to your buyer's lender, because there's a limit on how many closing costs the buyer actually has. And you don't want to negotiate for $20,000 worth of seller paid closing costs and then find out that the buyer only has $12,000 worth of closing costs available that can be paid for them, because you're going to lose the benefit of that $8,000 you negotiated for. So just be mindful of that. Okay, so taxes are going to be prorated. And they use the prior year's tax value, even if the estimates are out. So if you want them to use this year's value, you have to ask. So call me about that. But basically they prorate the taxes. So if they close on, June 30th, the buyer's going to pay taxes for the first half of the year and the seller's going to pay taxes for the second half of the year. And the tax bill isn't out. So what's going to happen is the seller is going to receive a credit from the buyer because they're going to have to pay the taxes at the end of the year. And what this says, and the parties will sign a document at closing, that if the prorations were widely off from what actually the tax bill was, the seller can go back to the buyer and say, hey, you owe me X amount. And the title company will help you with those calculations. Okay, casualty loss. This is a paragraph we become very familiar with. If there's a fire or a tornado or anything like that, it's what happens if the property is like extremely damaged during the course of the contract. Default, this one's important. If buyer fails to comply, buyer's in default and seller can enforce specific performance, which means sue them, right? To sell the property or to seek other relief or damages, or they can terminate the contract and receive the earnest money and just accept that that's what they're getting, right? So that's the earnest money there. If seller fails to comply, they're in default and buyer can sue to enforce specific performance or for other damages, or they can terminate and receive the earnest money back, which is really not that sweet because it's the buyer's earnest money in the first place. So those are the options. There's a mediation provision. Whoever wins is entitled to reasonable attorney's fees. This paragraph 18 discusses what the escrow agent needs to do. If you ever get in an earnest money dispute situation, this demand paragraph is going to dictate how we handle that, but just call me and I can help you through it. This is where, sellers making representations that must be accurate. The contract expressly provides that the seller continue to show the property and receive. That's just interesting that that's in there. And then this says if the seller is a foreign person, you need to let the title company know ASAP because the title company is going to have to withhold funds and they're going to have to sign this like FERPTA affidavit, which is for foreign people because we hold their taxes for them. If the buyer is a foreign person, it doesn't matter. Okay, so I'll breeze through this because we're almost at the end of our time. If you need to go, no big deal. So notices. So they made a change here where you can put yourself. So you would put, CC buyer's agent, or you could put your email, whatever, CC's buyer's agent, or, Serena at Briggs Freeman, whatever you want to put there so that you are included, right? Your contact information is what I would do. What you don't want is for the other party's side to be totally blank. So now that we have this blank, if it's Adam's listing, I would put this. And that way, I'm getting a copy and he's getting a copy. So we're covered that there's at least someone we need to give notice to. Now, if I put my buyer's email in here or they put their seller's email in here, technically, you have to, please note, all notices must be in writing and are infected to be delivered as follows. So if they put their seller's email in here, if you're terminating because of option or delivering some type of official notice, you want to include everything that's on this side. So typically we just leave it to emails, but be mindful of that as a buyer's agent. We just had one where, generally speaking, in the industry, people don't, and they still accept it. But I would be really, really careful if there's an email address in here, Serene 123. If the seller's email is in here, when you're giving any type of official notice, send it to both and put the title company on there too. Just let everybody know when you're doing official communications. It's one thing to email the listing agent back and forth about deal terms and what's going on. But if you're delivering some type of official notice, like a termination or an amendment or anything like that, put everyone that you see on here. Okay. That's my tip. Any questions about that?
So do you recommend just doing buyer and listing agent, or do you have to have the personal buyer and seller's emails too?
I mean, if you're writing an offer, it can't hurt to put your buyer's contact information in here, because if the seller ever has to deliver official notice and they don't, then arguably you can say, well, you didn't deliver the notice under
Okay.
So I would. Some people are like, I don't want the other side to have my client's contact information, but I think that's silly. But at minimum, you want to put the listing agent's contact information in here when you're writing an offer.
Great.
And that's a new blank as of like this version of the form, and it's a good one because then you know who to send stuff to. If the listing agent puts in their client's information, just note it. But at least you have this, right?
Got it.
Okay. So then here's where you check the box for any other addendums that you're adding. If you're doing seller financing, if there's a contingency, of course, we're always going to add our square footage disclosure here. We're going to add it on the listing side. On the buy side, we have the clients sign it, but we do not give it to the other side. Does that make sense? I want you guys to remember that. So we have this Briggs Freeman square footage disclosure, and it's an excellent CYA document because it makes you have the conversation with the buyer of like, these are all of the square footages that we're aware of. If square footage is super important to you, you need to have it measured. So we include that as part of our listing paperwork, and we absolutely require that buyers who are buying our listings sign it so that we've covered ourselves. But we also want you to have your own buyer sign it, but we're not going to deliver it to the other side because it's our document, right? And it also like protects the seller a little bit. So we don't want that, but we just want to have it to protect us against our own buyer. Does that make sense? Yes.
Yes.
Okay, perfect. Okay, so if your clients happen to have an attorney, you can fill this in. Most don't. This is what will be filled in. The last agent that sends it back to the other side fully executed will fill this in. The parties sign here. And then, this is where you put the listing broker, all of their information. If you're writing the offer and it's not a Briggs Freeman listing, your information goes over here. If Adam is writing an offer on Sophie's listing, we're going to put Briggs Freeman here. And then we're going to say seller and buyer is an intermediary. And, Sophie's name is going to go up here because she's the listing agent, and Adam's name is going to go down here. And there's going to be nothing on this side because there's no other broker. And we see like very, very experienced agents that still don't fill this out the right way. And they would put Adam's stuff over here and Sophie's stuff over here. And that's not right. If Briggs Freeman is the intermediary, we only fill out this side. And then you don't need to fill this out if Briggs Freeman is the intermediary because there's no other broker, and we'll sort that out among ourselves. If, Keller Williams is the listing agent, then you do need to say, 3% or whatever was marketed in the MLS as the commission. Does that make sense? And if it says 2% in the MLS, you can't write 3% in here and then be like, oh, you owe me 3%. It's whatever's marketed in the MLS is what you will be paid. And then this will be filled out by the title company when the money is received. And that's all we have. Does anyone have questions? Do we need to go back to anything? That was a lot of information and I talk fast. Go ahead, Adam.
If I'm writing an offer, proof of funds, if it's a cash buyer, could you speak to that in Texas? Like how much is too much information to provide?
Yeah, it's a great question. So, and that brings up a good point in general. When you're writing an offer, you want to submit either, proof of funds if it's cash, or you want to send in hopefully a pre-approval letter saying the buyer is totally approved. That's not always the case. Although in this competitive market, I really recommend just having your buyer go through the process so that that's one less contingency. Or you want to send in, the information from the lender saying, I've talked to this buyer, I've gotten X, Y, and Z, and they are approved to purchase this price. The listing agent and the seller just want to see that the buyer has their financing ducks in a row, or to Adam's point, if they're paying cash, that they actually have the cash. And there's different ways to do it. Like if they're a private wealth management client with JP Morgan, you can have their person say like, Sophie Gilmore has the cash in the accounts to purchase this property. It can be very generic. And if it's coming from like JP Morgan, great. We could also, all of us, Google and in 30 seconds get like a proof of funds letter from some weirdo like website, right? So sometimes people also take bank statements and they just cross out the details and the account numbers, but they show like, here's my bank statement with like $4 million in it, right? So there's not a one way to do it that's the right way. You just want it to be something that like looks credible and is credible. Does that make sense?
Yeah.
What's the
I guess
situation you're in?
Well, no. Just a question might come up with, if you're writing an offer for, say, $1 million and you're showing that you have 2 million in the bank, this, I don't know, just,
Yeah, no, I think that's good. I think it makes the seller feel good, like this person is well secured and it's like a legitimate cash offer.
Okay.
I wouldn't like move money around, so it's like just the right amount. I think just showing like this buyer is very liquid and like they're a true cash buyer is good. And it's not like something fishy looking or weird looking. To that point, when you have your lender write the pre-approval letter, I have seen ones like if it's a $450,000 offer and the lender has written just like a generic pre-approval letter for up to 550, like that to me is dumb. Like I wouldn't do it that way, right? I would ask your lender, can you please write me a pre-approval letter that is specific to this property and this amount? And then if you negotiate back up and higher, they can update it. Realistically, what your lender should be doing, and this is what the connected guys do when their buyers write offers, they should call the listing agent and just say, hey, I'm the lender. I've talked to Adam's buyer, like they're super well qualified, like here's the deal, and just give the listing agent some peace of mind that your buyer is definitely already in the middle of the loan process and that the lender that they're working with is not a total moron, right? And that's what the connected guys do as part of their process and what your lenders all should be doing for you. It's just a nice touch. It's just an automatic like, hey, I saw that Adam's buyer so-and-so put in an offer with you. I just want to let you know, I've talked to them, like I've got X, Y, and Z, like they're really well qualified. We should be able to do this. If you have any questions, call me back. And it just is a good like peace of mind. Does that, any other questions? No? Okay, perfect. Well, thank you guys for showing up. We're, did you have more, Adam? Okay, we are going to keep doing these classes on Tuesdays and Fridays at 9, that cover like best practices and the things that you really, really need to know to be like operating at the top of the real estate game in general. So thanks for showing up. I'm going to share this recording with everyone who wasn't able to make it. I appreciate you guys. And we will see, there's no class on Friday because the office is closed, but we'll see you on Tuesday. Okay. Bye. Thanks.